08. This is ABC Auto Finance versus Terry L. Moore. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case by default on the 26th of October 2016. The judgment amount is $10,408.25. I reviewed the objections to the writ of garnishment, wherein there was no box check, but the defendant petitioner indicates that he paid this off years ago, and other reasons were indicated. For ABC Auto Finance, your appearance at this time, please.
Good morning, Your Honor. For the record, Jason Katz for the plaintiff.
All right, thank you, Mr. Katz. Your P number, if you will, for the record, sir.
P62923.
All right, thank you, Mr. Katz. I'm looking now for Mr. Moore, Terry Moore, please. If you're on the Zoom, say something at this time.
Yes, I am.
All right, good morning to you, Mr. Moore. As I noted, your objections here, you indicate that you paid this off years ago, and then you said there were other reasons as well. So the judgment, as I indicated, was entered in 2016. So you paid this off after 2016?
Yes, I had a car note. It's supposed to be for like 2 years. I ended up paying for 4. Then my car got into the accident. Then I had insurance on the car. I was paying insurance through the car note. And I heard nothing from them until like this year. And they took my federal income tax check too for $1,200. This been like, I had that car been over like 10 years ago. And I don't understand what's going on. I mean, I'm like, I don't know. I got kids. I got a mortgage. I'm sorry.
Yeah, let me stop. The challenge that you have here is that the file shows that you received personal service on this complaint back in September, I should say, September of 2016. You did not respond to the complaint. I also see that there was substituted service, it appears, where the previous judge on this matter allowed this to be served by substituted service, which is a way of getting jurisdiction or getting the right to have this case heard over you by sending it through the mail and by posting it. After that occurred, now you're listening to me. After that,
yes, I'm listening, sir. I'm listening.
After that occurred, that's when the judgment was entered by default. And that judgment was entered by default. Again, that was in 2016. So if you are, the only way that you show that you paid this off is to show that you paid the judgment since 2016. Because since 2016, there's been outstanding some $10,408. That's already been determined as the amount that you owe as of 2016. So if you have something to show me where you paid $10,400 since 2016, then you would be right that perhaps this is paid off. Do you have anything that you can show beginning in 2016 where you?
Yes, yes, that's what I'm saying, Your Honor. I paid, my car was only like $10,000 when I purchased the car. Now they try to charge me again another $10,000, and I paid the car note for 4 years.
I got to stop you.
Okay.
Apparently you purchased a car sometime before 2016.
Yes, sir.
The issue here is that in 2016, the court determined that you owe $10,000 as of 2016. Anything that you might have paid before that time is not relevant, because the amount that was determined by the court in 2016 by default was the $10,000 that's owed on this case, $10,400. So you would have to show what you paid since 2016. Not before that time, since 2016, because your judgment says that you owe $10,400. Now, that judgment was entered by default. If you believe for some reason that the judgment should not have been entered, then you have to file something else and try to get that set aside.
Okay, okay.
The reason that we're here today is to determine whether the judgment has been paid off, whether or not you filed bankruptcy, or whether you're under some type of other order or something along those lines. This is what's called post-judgment. The stuff that you're talking about seems to be that you're raising some issues of things that happened before the judgment was entered.
Yes.
Well, I can't go back and address those things. You would have to file something with the court, asking the court to set the judgment aside. And, again, at this point, you'd be asking the court to go back 6 or 7 years to set this aside. The question becomes, why haven't you brought something sooner to this time? Because there were several garnishments issued against you, and you filed various objections to those garnishments, but I don't see where there was any effort to get this judgment set aside in the previous years. So you said that, go ahead, sir, I'm listening to you now.
Your Honor, see, I've been dealing with cats and cats now over 20-some years. I was dealing with the other car that I had a judge rule in my favor. Now, this car I'm talking about, it was a green Envoy. I hope we're talking about the same car. And I had paid car notes on that. So I don't know which car. And then I never had nothing sent to me because I moved from my other house into a reference. I had nothing sent to me. Only thing I got something sent to me that I work at Detroit Golf Club, and the lady working in the office, she gave me that letter. So then I went down to court to file this. I had nothing say I owe that because as far as my knowledge, the car was paid for. It's just the same car we're talking about, the Envoy. They've been after me over 20-some years.
All right. By way of reiteration, the judgment was entered in 2016. After that time, there were several garnishments filed against you. And it looks like there were even times where you objected to the garnishment. So you knew about this as early as, now listen to me. I'm looking at the file here. I wasn't.
No. I'm listening. I'm listening to you. I'm not trying to interrupt. I'm sorry. I'm listening. I'm trying to like. Go ahead.
I wasn't on this file in 2017, so
okay.
I'm looking at your documents where you filed objections to garnishments and whatever and you had various hearings over the years on this, and you've not moved to set this aside before. That's the issue that I'm raising with you.
No.
All right. Let me hear from Mr. Katz.
Okay.
Sir.
Oh, okay, Your Honor. Yeah, this is a case actually was not my firm's case initially. It was another lawyer who got the judgment, and then we substituted in as counsel back in 2018. So my office may have had another case with Mr. Moore, but I'd have to look at that. I don't know. But with respect to this case, ABC Auto Finance, we substituted in back in 2018. I'm looking at my records. With respect to the balance, there's still a balance owing. It looks like at some point there was a wage withholding order, so we were receiving payments from. It looks like maybe Plum Hollow Golf Course. I'm guessing he must have left at some point because those payments ended. So we filed the new garnishment at Detroit Golf Club, and as the court is probably aware, the process is we file with the employer. The employer serves in the garnishment, which is what happened here. So that's what we did. We received payments over the years; those have all been credited, but there's still a balance owing because those payments have been inconsistent. And so, I mean, our position is that the objection is not proper.
All right, and what do you have? What do you have as a balance at this point?
Balance is $9,714.97.
All right, Mr. Moore, you had something else you wanted to say, sir.
Yes, see, that's not the green Envoy. That's for the little white car. They were like a 96, 97. They've been after me since 2000. I was working at Plum Hollow for like 10 years till I moved to Detroit Golf Club. That case been like over 20 years. That's the same one he's talking about. I do remember that. And then I had a judgment in my favor. They threw it out. Then I guess they went back and did it again. That car, that's been over 20 years, Your Honor. Been over 20 years. Because he said I worked at Plum Hollow. I know exactly what he's talking about now. Because I never got nothing here for Detroit Golf Club. I've been here for like 5 years.
Right. All right. So you got the judgment from 2016, and the reality of it is that if this is not resolved or paid off, then the judgment can be extended another 10 years.
Wow.
In 2026. In other words, these type of things don't go away except through some type of payment. You have to pay them or reach some agreement where you pay a lump sum and try to settle it out. That's the only way that that's the only way it's going anywhere. It's
Yes,
gotta be paid.
Your Honor, that's what I'm saying. I went to court and I paid that off, and then they ruled in my favor. And then they came back and got me again. This 10,000. I mean, I'm paying the card like triple time over again. I don't get that. I haven't did.
You probably are. You probably are. But what you want to do is you want to go to the Michigan legislature and get them to change the law that won't allow people to collect on a debt that is ongoing. Debt collection is as sure as death. As long as you owe money, the debt collectors are going to come to try and collect on the money that they owe. And one of the ways, of course, that you deal with that is if you believe that you have the rights to do it, you go to bankruptcy and try to bankrupt the debt. Other ways that you deal.
But can you
I see you want to talk. I've let you talk a lot, and I think I think you picked up that I don't appreciate being interrupted because I don't have time for that. So what else you got to tell me?
No, I'm saying, what about the $1,200? They took my federal income tax too. They took that out. So did he subtract that from that?
If $1,200 was taken from you, it has to be subtracted from the judgment. Your problem that you have is with the judgment in place, you have interest that continues to accrue on it. Yes. And as long as that interest is accruing on it, the longer it hangs out there, you pay some money and interest is still accruing. So a lot of times you're running, but you're almost running in place. So this judgment was entered in 2016 for $10,400, and even though you made a number of payments, it's now some 9,000 and something, and that's because of interest. So you probably need to look at some ways, and maybe you can talk about how to settle it out with a lump sum.
Yes.
So over time, I'll get an opportunity to do that. But as it relates to the objections to the writ of garnishment, I don't see that there is a valid objection. That still means that you can file something if you believe the judgment should be set aside and try it that way. But as far as the objections to the writ of garnishment, objections, I don't find any validity in those under the law. So therefore, I'll find them invalid. I'll release any funds withheld to the plaintiff in this matter. Now, I see that it has Detroit Golf Club. Is that where you work?
Yes, sir.
All right. How much do they pay you on a bi-weekly? You get paid bi-weekly, twice a month, or every week?
By week.
All right. So how much do they take? Have they taken out some money for garnishment there?
Yeah, they took $300 last week, and the week before they took about like $250.
About $250. So your garnishment is somewhere in the range of $500 to $600 a month, correct, sir?
No, it's like 3, 6, 9, about $1,200.
You said you get paid every other week, or do you get paid every week?
I get paid every week, sir. You just had the Rocket mortgage here.
Okay, so you get paid. So they take out about $1,200 a month. Then I got you.
Yes.
Okay. No. How much do you believe that you can pay on this voluntarily, sir?
By like every monthly or weekly? I pay about like about $400 because my mortgage is $1,050. I got my grandkids about to move in with me. I got other bills. Bill over $2,000. I mean, I really can't afford that. I mean, it's hurting me.
I got you. I understand. That's why I asked you the questions.
Yes, sir.
All right, Mr. Katz, anything you can say? Excuse me, Mr. Katz, anything at this point? I was going to put the two of you in a breakout room to try to figure out if there's a way to bring this to some type of plan where it could get paid off with perhaps some reduced payment amount. I don't know if that will work. We could talk about that. The defendant indicates that he could pay $400 a month. I know that his garnishment rate is about $1,200 a month, and I also know that if he stays on the garnished amount, then maybe you could reach some type of agreement where this gets settled out in a relatively short period of time. I don't know. You want to talk about that? I'll set it up. I have a breakout room where you can do.
Yes, Your Honor, two things. Number one, I'm certainly willing to talk about a payment plan with Mr. Moore. But just to clarify the record, I just want to be clear with the court that this is not a 20-year-old case. This is I have a feeling.
Let me stop you, Mr. Katz, and I certainly appreciate that. What I go by, whether or not, listen, apparently there's something to do with a car loan. Anything that happened before this case came to court, I don't have any dealings with that. I mean, the fact of the matter is that the judgment was entered in 2016 for this court. I have to start there because that judgment was entered then, and it was $10,400. I understand that sometimes when there is a car purchase or whatever, that a person can be paying for years, maybe they get an extension to try and pay it off, whatever they do. If at the end there is an indebtedness and that debt is sued on, that's what comes to court. And so I didn't mean to cut you off. I just want to say that in 2016, a judge entered, it wasn't me, but another judge determined that there was a basis to enter a judgment for some $10,400, sir. Mr. Cash, you may continue, sir.
Yeah, I just wanted, and I can explain this to Mr. Moore as well. I'll have to look through my files, but my impression is that this is I've only had this clients in 2018. I'm guessing that he's confusing that there's a second car with another client that maybe he had another judgment with. And I'll get that information from Mr. Moore. I don't want him to be confused. I have a feeling there's two separate cars, and that's why he's talking about something happening 20 years ago. I just want to be clear to the court. This is not a 20-year-old case. And for the record, we have stopped adding any interest to this case as well. So in many cases, we'll just cease interest. I understand it's at some point you're spinning your wheels. So I want to be clear with the court. This isn't a 20-year-old case. I have a feeling there's an old judgment, and I'll get that information for Mr. Moore. And then with respect to a payment plan, I'm happy to talk to him in a breakout room, or if he wants to call our office. I understand that sometimes it's self-defeating to garnish this much money. So I'm happy to try to work it out. However we want to do it.
Yes, I'd like to work it out with you too.
Yeah, I'm going to give the notification now to breakout room number 1 and see if you can get somewhere. There's more than one issue, of course. And so if you can get to where in a relatively short period of time, then let's try to do that. If not, you come back in. Either way, you come back in, and then we'll figure it out. What is the best course to take? So, Mr. Katz, I just sent you a notification, and I'm sending you one as well, Mr. Moore. So go ahead and click in, and I'll stand down until the two of you are able to return.
All right. Thank you.
Hello?
Yeah, just go ahead and click on your phone, the notification, sir.
Say, click on my phone notification. Say, click on my phone notification.
Put it on notification?
Yeah.
Yeah, I should tell you, go to the breakout room. All right, the court now calls case number 03145319. This is People Driven Credit Union versus Marcellus Travers. The matter is before the court on the filing of a motion to dismiss garnishment in this matter. All right, your appearance for the plaintiff regarding this matter, counsel.
Your Honor, Michael T. Mamet, P81102 on behalf of plaintiff.
All right, thank you, counsel. Give me your P number, if you will, for the record, sir.
Well, P81102.
All right, thank you, counsel. Good morning to you. I'm looking
Good morning,
for Mr. Is it Travers? All right, thank you, sir. Good morning to you. Mr. Marcellus Travers is in the courtroom at this time, and he's brought a motion to dismiss the garnishment and the judgment in this matter. The record should reflect that the judgment was entered by, just one moment, I'll reflect on it. The judgment was entered, was renewed on the 18th of March of 2014 for $20,329. That was based upon a previous judgment that had been entered by the court back in, it looks like 2004. March 20, 2004, the judgment was entered by default, And then that judgment was entered by renewal in 2014 pursuant to statute. All right, Mr. Travers, tell me what you're asking the court to do, sir.
I'm asking the court to dismiss this case because I never had a car loan or applied for a car loan to this people-driven credit union, nor under the name of Marcel Travers. I never used this PO box, this address they saying I used. I have revelations in the past 2 years that I've been a target of identity theft through my own family, and I have filed a police report last year. This garnishment for this auto loan is the first time I'm hearing about this year. That's why I was so proactive on getting it going to have it dismissed. I have a police report for stolen checks from a residence house where I was using a mailing address. I also have a credit card that was applied for in my name that I had to have it removed off of my credit report. And I also have history documentations of past auto loans I've had in the last 8 years with other entities showing that I paid it off and that I'm continuing to pay off the car loan I have now. I'm responsible in all my actions, but this garnishment I've never heard of until this year. That's why I was in June when I had the Zoom meeting with you. I expressed that. Said the next step I have to do is file a motion to dismiss. That's what I did that day or the following day. I have documentation of the current credit union I'm at with history of the auto loans I have current. And I also have documentation of credit acceptance from the auto loan that I paid off.
All right, sir. Counsel, did you receive the motion in this matter, sir?
I did not, Your Honor, and he referenced the matter from, I believe, in June. We never received a notice of hearing or motion or an objection for that as well. However, if he's attempting to object to the garnishment, the court's already issued an order and a motion for installment pay or an order for installment payments back in June on this matter as well, I believe.
Right.
That was a volunteer.
Excuse me.
But as far as this possible objection to garnishment, all he's attempting to do now is attack the underlying judgment, which is expressly prohibited under the Michigan court rules.
Yeah, what defendant has done is not does not fit within that rubric because he filed a motion to dismiss garnishment and judgment. And that's why I was asking whether or not you had received that, because the court ruled upon the issue relative to the garnishment at a previous hearing. This is in the nature of a motion to dismiss garnishment and the motion to dismiss the judgment under a claim of identity theft, or that this is not the defendant's debt. So if you have not received that, then I need to make sure that you get a copy of the motion that he's filed, so that we can so that you can comprehensively respond to the various items that the defendant has submitted to the court. Let me say to you, Mr. Starr, it doesn't matter whether or not you have current loans or if you paid loans off. None of that matters. But what matters is whether or not this is your loan, and more importantly, whether or not you reacted to it in a timely way. This goes back to at least the filing with the court in 2003. Back in 2003, there's a notation on the file that the summons and complaint was served personally, and there is also the subsequent to that time, the judgment was entered by default. That was back in 2004. After the entry of that judgment by default, there were a number of writs of garnishment, periodic garnishments that were issued over the years. and a writ of garnishment against income taxes issued over the years 2004, 5, 6, 7, 8, 9, 2012. And subsequent to that, and 2012, 13, and then subsequent to that time, comes 2014, and that's when the judgment was renewed, and that would be renewed, what's called ex parte. You would not receive a notice that that's being renewed. By law, it's renewed ex parte. So the history of the file, and then again, since 2014, it shows that there were garnishments issued subsequent to 2014. And so your first reaction to this occurs this year. And over that period of time, there are a number of garnishments that have been filed against you, and all of these are related to the address on Fall Street. And I noticed that that's the notice where the court sent. That's where the court sent you a notice. I noticed that in the filing of the documents that you recently filed, you indicated an address in Dearborn Heights. All right, so the history of the file shows that there were a number of notices that were directed to you regarding wage garnishments to income tax garnishments, and you never responded to any of them over the years. Do you go by some other identity other than Mr.
No.
I'm sorry?
I don't go by any other identity except Marcellus Travers. And to my knowledge and my remembrance, I've never been served any garnishment or judgment. I've never been judged, never been served.
Well, you might be a little bit too far behind to even address that because of those garnishments over the years that there was no response.
I had no knowledge of garnishment taken out of my checks previous to this year. This is the first time I'm really.
Well, not out of your check income tax intercepts.
Oh yeah, I never got an income tax since 2000 because of student loans. I thought everything that I didn't receive went towards student loans.
Yeah, that was some of that was regarding this case.
I had no idea of that, sir.
All right, so counsel, I'm going to the defendant indicates that he filed an affidavit of identity theft. And have you received any information from the defendant regarding his complaint or his report regarding identity theft?
Oh, Your Honor, not to this point.
Okay. All right, so you're gonna want to send a copy of that information to the attorney so that internally they can investigate whether or not this is a case of identity theft from their perspective. And then you're also going to want to send a copy of your motion back. What we'll do, I'll make sure that what you file with the court gets sent to to the attorney. And then if you will give that to my officer, he'll have my clerk to make a copy of that. Counsel, we're going to send to you whatever information we have here, and then I'll reset the hearing to address these issues. Let me ask you, counsel, if you know whether or not this indebtedness was ever in any other name other than people-driven credit union. Oftentimes what happens is over the period of an indebtedness that lasts this long is that debt is sold, sometimes it's sold from one creditor to another creditor. If you know, counsel, you have any information on the background to this?
Your Honor, my records only go back to 2007. However, I can say with almost absolute certainty that the debt would not have been sold. The only name change that would have occurred is if one of my clients had merged or bought out another credit union that was holding the original note. So I gotta look through our basement and see if we still have physical files down there dating back to 2004.
Right. All right. So I'll get that information over to you, and I will set a new date on this. You got an uphill battle because how long it's been around. You can't, don't matter. You can't just walk in and say, you know what, Judge, that judgment that was entered in 2004, that was directed to me. That was the false address that a bailiff says that he served all that time. That now in 2022, I want you to know, Judge, that didn't happen.
I didn't have no knowledge of it.
Don't matter.
Oh,
No,
no.
it doesn't matter much, except for the fact that there were wage intercepts. So I should not wage intercept, but income tax intercept. The fact that you may have missed that and haven't reacted to this in 10+ years, that's problematic. Obviously, if you can show, and that's your uphill battle, if you can show that there was some type of identity theft or that somebody else used your name, the fact that you say that,
Okay.
that, you know, I don't mean anything, but if we can,
I have documentation from identity theft email with case number 208707766, talking about the case summary right here to show what I need to do as far as.
well, I think
going
that
about
I
it.
think that what you're talking about is the affidavits and what have you that you may have filed. So you can,
This is before I even heard about the garnishment.
yeah, but that's still, I mean, that doesn't matter a whole lot because the judgment has been in place since 2004.
Yes.
And then the judgment got renewed in 2014. So, you know, I mean, it's, I don't know how you're gonna get over the hump, but get hand the documents to my officer. He's gonna make a copy. My clerk is gonna make a copy. We're gonna make sure that the attorney for the creditor gets a copy of those documents, and I'm gonna set a hearing date after you had a chance to review those items. And Madam Clerk, we want to copy these as well. We're gonna get those sent out to Mr. To the attorney for the creditor. And then the next, what is that?
I have the motion to dismiss, a copy of it and an
Well,
addendum.
That's when you already sent that to me.
Yeah, I sent that.
You didn't
They
send-
didn't have it.
No, that's what I'm having that copy because I already have that. So we're gonna send those items to you, counsel, and I'm gonna set a new hearing date. Let's set that. That'll come.
Thirty-first,
Not of August.
oh, you want in September,
Yeah, put it.
the 12th, September 12th.
All right, 9/12. 22 at 9:45 a.m. 9/12/22, 9:45 a.m. I'll take this matter at that time. Council, we're gonna get the copies out to you. And a new notice will be generated as well, that will be sent out. Now, Mr. Travers, the address that you're using is the address in Dearborn Heights, is that correct?
Yes.
All right, so we're gonna make sure that the notice gets changed to that particular address. That address is on his motion to dismiss. Madam Clerk, you see that?
You said what now?
That the new address for the notice
Mhm.
is in Dearborn Heights, and if you look on that top document, you see the defendant's new address.
Yes,
Let's make sure that gets changed.
okay.
All right, so you get a notice of the date to come back, you should note it at this time, and I'll address these issues at that time. All right, counsel, we're getting that out to you, right? You have an email address, if you chat me an email address, counsel, I'll have my clerk to email the documents to you right away.
Perfect,
just put
John.
it-
Thank you. And as we've been talking, I went back a little further in my notes as I could, and it looks like in 2014, we did have to amend the case caption. I believe prior to that, the plaintiff was People's Trust Credit Union. So it would seem that they either merged or People Driven had bought out another credit union. I'm not sure if the ROA or anything reflects that information.
Let me see the work of this. Yeah, the RA. Yeah.
But once again, I can say with almost absolute certainty that the note wouldn't have been sold. It would only be transferred from the credit unions that either merged or if one had bought one out.
All right. Yeah, I only raised that, yeah, I only raised that because of, yeah, I do see People's Trust Credit Union. And I see the amendment. I see the motion to amend the name, that dates back to them. And so, yeah, I do see that. So we'll address that at the next. So this was previously, this debt was previously under the name of People's Trust Credit Union.
I never followed
Yeah,
a loan application with that.
that's okay. You still, yeah, but you still have this judgment against you.
That's why I'm here now. Just wanna,
You're here now,
Get it straightened out.
15 years later.
this is my first time hearing about it.
It
That's
couldn't
why
possibly be. Now,
being proactive
it
about
couldn't possibly be your first time because your income tax was garnished because of this.
it. I didn't know.
But
I
you're
thought it was
supposed to, that's what
student
you're supposed to
loans.
know. That doesn't mean that you can't get to a finish line here, but you have to acknowledge what has occurred along the way. That's the challenge here.
My tax return never.
Okay. Now you're gonna get on my nerve
I'm sorry.
because you probably know that you can't overtalk me. You probably know that.
I'm not trying to.
And you should. That's when I'm talking about something, that's when you should be quiet, not because of some arrogance or something, but because my responsibility is just that. My responsibility is to say what goes on in this case. And you don't interrupt me. You just don't do that part, okay? So we're gonna set a new date. I want you to see the facts, what the Register of Action showed. And I'm gonna have my clerk to copy that now and give you a copy of the Register of Action. That shows the history of what happened in this file. And you'll be able to see from 2003 all the way up to now, exactly what happened in this file. So she's gonna give you a copy of that, so that you can look at what has occurred. And that's what I go by, because that's what happened over the history of this file. And whether or not you covered everything or you missed something or whatever, we can address all of that, but that's, the history is what it is, okay? So I want you to have a copy of that. That's what they're handing you now, okay? Go ahead, sir.
Like I said, all the times I file my taxes for work, this has never shown up. You know, and to my knowledge, since I wasn't receiving a refund, I just figured it was student loans, federal student loans.
That was the wrong figuring,
Yeah.
is what I'm telling you.
My tax
Okay,
return never
we'll
told me.
address all of that. We'll address all of that. And those are the kind of things that put you on notice, if not, even if other things did. But again, there are some other issues involved in this. I'm gonna get the file. It's an old file. I only have the jacket today. I'll have the file the next time that you show up. And council, we're gonna email you the items that we have so that you'll be ready for the next hearing as well. All right, we'll see.
One more thing.
Yeah.
One more thing. Since I've been dealing with this address on false, my mother passed away in 1996.
Yeah, I'm sorry to hear that.
And I was a senior in high school. I went away to college, to Morris Brown College, played a little basketball. Ever since then, it's been little things happening as far as my social security, as far as my ID goes, because I'm getting all my mail was sent to my sister's house. And ever since then, up until I found that my stimulus checks were stolen and that I had a credit card applied for in my name, that's when I became proactive and saying, no, something isn't right.
You may very well be right. Obviously, if you're not right about everything, there seems to be some things that you're right about 100%. That somebody has found ways to compromise your credit and has taken your mail, et cetera, et cetera. But again, all I can address is this part. But it is important for you to be proactive, particularly in filing an affidavit of identity theft and getting a marker put on your Social Security and so on and so forth. So those things are important. We'll address the rest of this case on the next action.
Yes, I absolutely did that too. It was a hassle, but I did it.
Yeah, you have to.
This right here is the official. I never did anything with it. It still has my sister's address on it.
Right.
Unfortunately, I had to cut them off because it was just too unbearable to realize that this is happening. And this was in the last 2 years. So to hear that this has gone back all the way to 2003, 2004,
All right,
You know, I just want to get to the bottom of it, that's all.
all right. So, you got your date. I'll see you at that time.
Would that be a Zoom or in person?
You can do it either by Zoom or in person. Either one, whichever one you wish to do. Okay, I'm familiar with the case now. We've got the documents. And then the attorney will have a chance to go through them as well, and then we'll drill down on this and see which direction that this is going to go. All right, good day to you, sir.
Okay, well, remember June, you told me about a volunteer, $200.
Yeah, that still continues until
Okay,
we decide what this case
that's
is.
not a problem, but, I had a reimbursement of, from the attorney's office that
I don't know how that
they charged me over. They, instead of, my human resources department
Okay.
stopping the garnishment and me voluntarily paying,
Okay,
they didn't stop it for the whole month of
all
June.
right, got it.
So the law office reimbursed me a $509 check, which was it was $709 total.
Yeah.
But the $200 what I volunteered, so they reimbursed me a $509 check,
Yeah.
which I can't cash because it's not in my name. I can't deposit, it's in Marcel Travers, which is the garnishment is in the name of Marcel Travers. That's not my name.
I asked you that earlier. What's your name?
My name is Marcellus Travers. Marcellus, this is why I'm saying this is, you know,
All right, well, we'll,
that I had access to all my
I'm
info,
sure.
my social,
well, you want to talk on and on. I can't do that.
all right,
Let's figure out a way that the check can get reissued,
okay,
or you can sign it back over to them, and we'll suspend the monthly payments to accommodate for the check. You understand what I'm saying?
yes,
So essentially, you're paying $200 a month. If we send the check back, then you would not pay 2.5 payments, and then that will cover for the check. All right, Council, you understand what's being talked about here?
Oh, no, sorry, I missed that, the last moment there.
Yes,
However,
sir.
in, on July 24th, I believe, or 26th, the defendant did contact our office with the discrepancy in the name. And he was told at that point to return the check to our office and we would cut him another one.
I'm telling you that,
Well, that's another way, the way you're hearing it now.
I hear
If you could, that's the other way that you would do
it,
it,
okay,
is to return the check and they'll issue another one. And just send it with a note that it needs to be issued in this name,
okay,
and then they should issue a check. If that doesn't get worked out, when you come back on the 12th, we'll deal with that at that time.
okay.
All right. Wish you well. See you at that time.
All right. Then
Thank you,
is, I'm sorry, Your Honor, is he planning to return the check to our office?
Yes, you're gonna return the check to the
All right.
office.
Perfect,
All right,
not a problem. Thank you.
all right.
Have a good day,
Okay,
Your
we'll
Honor.
see you. All right. Thank you for your patience, Mr. Katz, and I saw Mr. Moore on this Zoom. All right, welcome back. I didn't know I'd be tied up as much. And Mr. Canine, I'll be right with you, sir. I didn't know that would take as long as it took. Tell me, have you made any progress or what we need to do at this point? Looking for the file.
Jason Michael Phillips.
You need me to go back on the record?
They no longer deal with it.
Just one second, gentlemen. Yeah.
Who's trying to-
Oh, I'm sorry. Yeah, so we're back on the record in 19 as the suffix. No, that's not, that's Travis. I'm looking for, Morris. Well, just give me the last four digits.
Mr. Morris, 4608.
4608. We're back on the record in 4608. Oh, yeah, and I do that. Thank you. Thank you, Madam Clerk. That's ABC versus Moore. All right, go right ahead, counsel.
For the record again, Jason Katz for the plaintiff. Yeah, I spoke with Mr. Moore. I believe we worked out a resolution for a payment plan. And in addition, I've indicated to Mr. Moore, if he makes a certain amount of payments, he makes them all on time, we're gonna cut the balance. We're gonna cut about anywhere from about $1,700 to $1,500 off the balance. So we reached the agreement. I'm wondering if I draft something up, is there an email address or a fax number I can send to the court to expedite this a little bit?
Yep. I'm gonna give you the, email address. So, Mr. Moore, you worked out something, is that correct, sir?
Yes, sir.
All right. And so, Mr. Katz is gonna get that to me, whatever, agreement you all have reached. And I certainly, trust that it will work out well. So the email address, Mr. Katz, is gonna be, at Latifa, it's Latifa, LATIFAH .Hunter @36districtcourt.org, 36th, 36districtcourt.org.
Okay, Latifa.hunter@36thdc.org.
That's correct, sir.
Okay, so I'll prepare that. I said I'm gonna send that to Mr. Moore. I'm gonna try to get it to him this afternoon. And then as soon as he gets it back to me, I'll send it to the court and we'll have the employer's address so the court can send it to the employer.
Absolutely. Sounds good. All right. And you'll get it with my signature on it, Mr. Moore. And we trust that everything works out. with this, sir. Okay?
Cases.
All the best to you.
Okay, thank you, Your Honor.
Thank you, Your Honor. Nice to see you.
Nice to see you as well.
Okay,
Good day.
I won't go down there.
Mr. Canine, you indicated, you sent me something, I think I.
Didn't close off. So y'all gotta hang up now.
Oh, I also have you here. I got here this information, so I get a chance, buy me some time.
You have been assigned to room 1.
Which case were you on, Mr. Canine?
Synchrony Bank versus Deborah Brown, Your Honor. Last 3 are 332.
Oh, that's consent judgment that's canceled. They consented that the term.
Oh, yeah.
of the consent
We
judgment.
have the notice that, that the hearing was canceled because there's a consent.
Fabulous.
Have you sent the consent already, or we're waiting it, or?
It's right here.
Oh, got it right here. All right. All right.
Just
It's good to have a good clerk. All right. We'll get it out to you right away.
fantastic. Thank you, Your Honor. Better safe than sorry. So
Yes, sir. Yes, sir.
Thank
Good
you.
day to you.
likewise. Bye-bye.
You say you want this 03 file, right?
Yes.
Okay.